So when you started doing that, did the prosecution go wild?
No, they didn't know what to do. They were caught off guard. They
They're-
tried to cross-examine him, and he held up on his own, and the jury came back not guilty. I
Because
was
they
shocked. I was a
because the
huge
jury
shock.
thought that, well, this is a plausible story. The guy
Right.
he had a
In a
crazy.
carjacked car, robbing a Taco Bell,
Now was
and the
here
cousin pled guilty.
and was the and so is the was the client at least grateful or no?
No, they're never grateful. It's okay.
All right, everyone, welcome. Episode number 2 with one of my lifelong friends and criminal defense attorney, Mr. Philly himself, Scott Sigman. Welcome, Scott.
Welcome. How are you, Attorney Rockland?
I am great. Thank you for coming on. So, a little bit of background. So, I have this podcast I'm trying out, just interviewing interesting people about their lives and what they do. Some of it is law, some of it is not. I guess we can give a little background. So I met you in 1993. I think that's right.
Yeah, we met in 1993 in Washington, D.C.
At American University.
Many trips to Philly and New Haven.
That's right. That's right. So Scott and I met at American University in Washington, D.C. since 1993. We lived together. We practiced law together. And I'm a divorce attorney up in Connecticut. Scott's a trial lawyer, primarily focused on criminal defense work. You've been a lawyer over 20 years now, right?
That's right. 20 plus years of criminal defense, mostly in Philadelphia, but also in some of the counties.
Right. And some of the counties as well. All right. So you were previously, just to give people some background, you previously worked as a prosecutor in the Public Nuisance Task Force, if I remember that correctly.
So I worked for the Philadelphia District Attorney's Office, and I handled cases involving drugs, guns, drug houses, nuisance bars, and brothels, houses of prostitution,
Brothels.
vice. So it was drugs and vice, like Miami Vice, but Philly Vice. So we were partnered with the police in Philadelphia to go after these type of cases. A lot of drugs and guns.
A lot of drugs and guns. And how long did you do that for?
About 5 years.
5 years. And then you've been private since then. And that was from right out of law school, right? Right to the prosecutor's office. Is that right?
That was actually during law school. In Pennsylvania, you could be certified as a legal intern.
Oh, I see.
I was actually trying some of those cases while in law school.
Right.
But yes, right as soon as I graduated, I got that job.
You got that job, and then you became an attorney and then worked there. And then how, just off the top of your head, now that you're on the other side of things, how many, just to orient the listeners, how many, let's do jury trials. Again, how many jury trials do you think you've taken to verdict in your 20 plus years?
Over 100.
Oh, more than that. You have to have more than 100.
Well over 100. I mean, I literally do a jury, some weeks, 2 juries a week, because they're 2 to 3 day juries.
Wow.
And sometimes a 1 day jury, where you pick a jury, open, close, charge, and verdict in the same day.
Right.
That's happened numerous times this year. I have literally a jury listed 1 a week.
All right. So I want to just
50 juries a year listed.
50. Okay. So, but let's talk about, because I want to talk about your system that you have in place and what you've been doing, because you've had, you and I talk multiple times a week and talk about your successes, and defense attorneys obviously measure successes and not guilty verdicts, or sometimes in the deals that they get. But mostly for you, somebody who's trying a lot of cases, you're measuring your successes on not guilties. Of course, whether or not they're guilty or not is a different issue, but that's the system,
Well,
right? I mean,
for the most part, I represent guilty people. So when I get a not guilty, it's very exciting because the person is usually guilty of the crime.
Well, all right.
It's not proven. It hasn't been proven.
Right. So, but all right, let's jump right into that then I'll give us more background, because that's an important point, because a lot of people think we're nuts when we smile and laugh at that. You're going to say, well, are you some sort of sociopath? How do you reconcile those two? The fact that you may in your heart think that somebody's guilty and they've committed a crime, and then you say, well, I got a not guilty verdict. Is that the right thing? And I always say, well, sure, it's the right thing, because the system requires that the state be held to their burden, which is beyond a reasonable doubt. Could you talk about how you reconcile that? Obviously, you're not a sociopath, but how do you reconcile that, the fact that some people that may walk that shouldn't, maybe?
So it's not my job to prove anything. The government has the burden the entire time to prove someone guilty beyond a reasonable doubt. So there's really 2 parts to it. It's not just one part. You're right. we have to hold them to their burden to prove them beyond a reasonable doubt. But under the law in the United States, and especially in Pennsylvania, the person seated in the courtroom that's charged with the crime is presumed innocent.
Right.
I'm not there to do anything. I point out the mistakes the police make. I point out the flaws of the case, which can be called reasonable doubt or the reason to pause, the reason not to find someone guilty because of mistakes and inconsistencies.
Right.
But it's not my job to do anything to prove. So if the case isn't won when the person is guilty, that's not my fault.
But
That
why is
is
that? But why is that morally right? Like, I think it is right that if they haven't met their burden, but we know that they're guilty, like why is that morally right and appropriate in our system? Like, why do you could you explain to people why that,
well.
it's hard for
So
people
there's
to lay people to get their head around this.
sure. The reason the Constitution is drafted that way is because we don't want the police or the government to have such a power that
Right.
if they accuse someone of a crime,
Right.
you're automatically considered guilty.
Right.
And then you're fighting, especially if you have no money, you're fighting from a hole in the ground
Right.
to get out of it when you're just automatically assumed or presumed guilty.
Right.
So our system is designed to protect people from innocently being convicted.
Right.
And that may let guilty people go free.
But that's the
But
price.
way the
That's the
system
price
is
of
designed.
freedom. Right.
Correct.
I like
That's
it.
the price.
That's the price of freedom. Now, in Pennsylvania, I was licensed there for a little bit. I'm actually retired now. That's my title there. But there's could you tell some of the listeners about the probable cause hearing that you guys are entitled to, and what types of cases allow for a probable cause hearing?
All right, sure. Good question. So outside of Pennsylvania, especially in New York and New Jersey, they use a grand jury system.
Right.
So it's a two-tiered system. What you consider a felony would get a grand jury and an indictment, and what would be a misdemeanor would probably not have that and would go more to a trial,
Right.
bench trial. In Pennsylvania, the system works this way. There are 67 counties. 66 counties work one way, and Philadelphia works different. In 66 counties, misdemeanors and felonies get a preliminary hearing or a probable cause hearing, and then go to the county's capital for a trial, whether it's a misdemeanor or felony.
Okay.
And the definition of misdemeanor or felony in Pennsylvania is misdemeanor is any crime punishable by 5 years or less in prison.
Okay.
A felony, 5 years or more in prison.
Right.
That's the simple distinction.
Right.
In 66 out of 67 counties, all misdemeanors and felonies get a probable cause hearing in the little town where the crime occurred.
Right.
And then the county capital, the seat of the county, every county has a capital.
Right.
There's a court of common pleas, which is the trial court, and that's where the trial happens for misdemeanors and felonies. In Philadelphia County, because the volume is so big, they divide misdemeanors and felonies into two groups. Misdemeanors go to a court called the Philadelphia Municipal Court. They get a bench trial. If you're found not guilty, the case is over forever. If you're found guilty, within 30 days, you can have a de novo jury trial.
And de novo
in the
means
court of common pleas.
a new, right? A fresh
Brand
look.
new.
Right.
Brand new. You could have the case held, tried again. Why? Because you don't get your opportunity for a jury. It's a bench only trial for misdemeanors. They do that because of the volume. Most people do not request a de novo trial for two main reasons. One, they're probably guilty. And two, if they go to the higher court, they're probably going to get a harsher sentence.
I see.
So they usually do nothing, and that becomes a final judgment, a final verdict. That's the municipal court. In Philadelphia, all felonies, anything 5 years or more,
Right.
that includes murder, aggravated assault, rape, sex offenses, and selling drugs. Those cases get a preliminary hearing in the municipal court. The Philadelphia Municipal Court gives a probable cause hearing. And then if the case is held for court, meaning there's probable cause, which is just more likely than not, then it goes to a jury trial or a bench trial in the court of common pleas. But it's your constitutional right for a jury. In Pennsylvania, the DA has the same right the defendant does. So either side can have a jury. Nobody has a right to a judge-only trial. In Pennsylvania, you have a right to a jury trial. So the DA can request a jury just like a defendant.
Oh, I see. So if the defendant requests a judge and the DA requests a jury, who wins?
There would be a jury trial. Your constitutional right to a jury, not a judge.
Oh, I see. So if the prosecution wants a jury, they'll get it.
Correct.
I see. Okay. Now, probable cause. You and I are talking a lot of inside baseball because we're both
probable
lawyers.
Cause, let me give you
Yeah.
the
Tell
easiest
people what the
explanation.
standard is. Yeah.
The standard is the scales of justice. You see, with the two scales balanced, and they're equally balanced. If you put a feather on one side, it tips ever so slightly in one way. So anything more than 50%, That's probable cause.
And that's
It
like,
means more likely than not likely.
and that's the same standard, like in a civil case, preponderance of the evidence, right?
Correct.
Right.
Preponderance of the evidence. Probable cause and preponderance of the evidence are the same legal standard.
Right. Right. And then the next standard
Beyond a
would be
reasonable doubt,
is the highest.
well, is the highest.
And then we
Clear and
have clear and
convincing.
convincing for
We
certain
don't really
civil.
deal with that too much in criminal.
Right.
In criminal, we're going to deal with beyond a reasonable doubt.
That's it. Right.
And that is the highest standard. It's basically almost certain, but if you have a reason to pause or a reason to hesitate, that's a reason to find
Right.
someone not guilty.
Right. Yeah, we have clear and convincing for contempt orders and civil things, and that's not beyond a reasonable doubt, but it's very high.
75%.
Yeah.
The estimate is if anything more than 50% is preponderance or probable cause. 75%, somewhere in that range, would be clear and convincing, and 99.9 would be beyond a reasonable doubt.
Right. Okay. So you get the probable cause hearing, and do you use the probable cause hearing as a investigative technique? What do you use it for as a criminal defense lawyer? If you know
Well,
it's going to be held for trial.
You're using it as free discovery because you're not entitled to discovery at this point. So you're using it as discovery and to help build a motion. You want to build your motion to suppress.
I see. So if the police
Although
made a
it's not
mistake,
intended for that.
what about though, like for instance, in criminal cases, like in Connecticut, you don't get to do a deposition or request they just have to provide you inculpatory and exculpatory material and Brady material and all that. But you don't get to do a deposition. Here you get basically a chance to question the police.
Correct.
And lock them into
or the witness or the victim.
Or the victim. Or the complaining witness.
You're questioning, right. We call them complainants. Some people call them victims.
Well, in my view, I never use the word victim because victim requires a judgment, right? I don't know if they're a victim. They've just made an allegation. Whether it happened or not is still to be determined, right?
That is spoken like a true defense attorney. We call them complainants. Complainants and basically civilian witness or a police witness, government witness or civilian witness. We get an opportunity to question them, see the evidence, and there has to be enough to have a prima facie case.
Have you ever get it thrown out at the probable cause hearing?
Yes.
How often does that happen?
Not often.
It's mostly held for
5%
trial.
of the time. 5%,
Right,
maybe.
but isn't part of the technique though that you lock in, let's say a police officer, a professional witness usually, you lock them into a story under oath?
Well, the key technique is you're right, because how many people can tell the same story 3 times? One time they tell the police in a police report.
Right.
So now they've said it 1 time. Now a preliminary hearing, they say it a 2nd time under oath.
Right.
And then at jury trial, they say it a 3rd time.
And it's usually
How
2
many
years
people
later.
can say the same story 3 times?
And is it usually 2 years later, right?
2 years later, right?
Right. So so when you're trying to sow the seeds of doubt within a jury, that to me, you think could be a critical thing, because you'd say to the police officer, well, wait a second, sir. You're saying today that the person was 6'3". Your police report says 5'4", and in the preliminary hearing you said 5'8".
Yes, exactly. That's correct.
And so tell me, the juries that for these criminal cases, where do they pull from?
Just the county. Juries come from the county.
Juries come from the county.
Philadelphia
So
County.
Philadelphia.
In Pennsylvania, the city and county of Philadelphia is the same size. All other counties are small. The cities are smaller. There is no other county and city that's the same size. Only Philadelphia.
So it's pulling. Is it a largely African American jury base?
Mostly.
Mostly. Okay. So you get these cases, and you're working 4 or 5 days a week in the what we call the CJC, right? In the
Criminal Justice Center.
Right across, diagonally across from the town hall or city hall, and so you're in there.
City Hall is where the civil courts are.
Right. Now, in Connecticut, you and I have talked about this extensively. We have individual voir dire. So sometimes it takes longer to pick a jury than it does to actually try the case. You guys don't have
cases, unless it's a child rape, I pick a jury in about an hour and a half.
So your system is an hour and a half. Now, what are you looking for? Because people tell me all the time, and maybe this doesn't apply to the system that you utilize, but that I do only judge bench side trials, that picking the jury can make or break your case. Do you agree with that?
Yes, I do. I need people that are going to have an open mind.
Okay.
Not prejudge my client who's seated there as guilty, and be able to listen to what story I'm able to tell in the courtroom.
But how do you when you question them, do you say to them, could you guys keep an open mind? Like, because there are people out there that don't keep an open mind, right? They'll tell you they will, but
there are general questions that are asked, and from some of those answers, I'm able to discern certain things. For example, are you more likely to believe a police officer because they're a police officer?
Oh, interesting.
Are you less likely to believe a police officer is a police officer? 9 out of 10 people say less likely, and that's my kind of juror in Philadelphia. When I'm in a county outside of Philadelphia, 9 out of 10 say I'm more likely to believe,
Right.
and that's not my kind of juror, because that means they're going to believe whatever the government says.
Right. So you want somebody
That's a
that'll
critical
be
part.
skeptical or cynical, whatever the case may
Correct.
be,
Correct.
and is willing to
Correct.
see that. And is that and are you drawing on? My guess is that you're drawing on, if this is a jury pulled from the city, African American, that you're pulling on some of their own life experiences with the police, which may not be
Correct.
positive.
Correct.
Right.
A
So
lot of them have relatives that have been arrested.
right. So and somebody may have been done dirty by a cop, and
Correct.
they have a predisposition for that. Okay. So
You got
you picked the jury very quickly. How much discovery have you done? Like, the police have turned stuff over, but are you able to, like, does the discovery matter a lot, or is it more about you taking what's there and sowing the doubt by
There's
exposing?
not much discovery, but I get police reports, and
Right.
I'm looking for the 3 different versions of a story. The police report not matching with the preliminary hearing testimony, not matching with
But
the
how do you get
statutory.
that? I mean, do you have a transcript from the prelim?
Yes,
And who provides that? Like a
the
stenographer?
court reporter, the
Oh,
stenographer.
and you
It's
get that
paid.
for
I
free?
mean, if no, it's you have to buy it unless you're court appointed, then it's free.
I see.
Otherwise, I'd have to pay for it.
Okay. So you
Several
get
hundred
that,
dollars.
you review that, and then you look at you're looking at it as you're questioning the witness?
Well, I highlight different statements they make in there that are critical to my case. I compare that to what they said in the police report, and when they testify live, if they say something
Then you
different, I
say,
got it.
aha, I got you.
Yeah, exactly.
So give us a technique. So if somebody give us one of your cases, like where that was critical, and you thought that you were able to, that was the basis for getting your not guilty verdict.
The one I had last week involved a woman who was badly beaten by her boyfriend. He beat her up, was in traffic on a 676 highway, and she ran out of the car into traffic. Someone called the state police, and she got back in his car. State police arrived, and she's seated in the car. He's got blood on his shoe, blood on his pants. She's got black eyes, bruises,
Oh
scratches,
boy.
ligature marks on her neck,
Oh gosh.
and held for court at the preliminary hearing. Jury trial. One of the key pieces of testimony I got was at the preliminary hearing, she said on my question on cross examination, he let me back in the car. He let me back in the car. So, how could it be false imprisonment if someone let you back in the car?
Oh, interesting.
And several other statements that I cross examined with, the jury came back not guilty, all charges on that case.
But
And he had blood on him.
but how did she testify?
She did.
So what did you talk to the jury afterwards?
Not in this case.
But what,
The defendant testified as well.
you put him on the stand?
Yes.
Now, a lot of defense attorneys will say, as a general rule, bad idea to put somebody on the stand. You tend to
Just
take a
depends on the
different
case.
approach.
You got it depends on the case. Every case is individual.
Right. But what
This case, he needed to go on the stand.
but tell me, but why did they not find that the state met their burden?
In this particular case, there was inconsistencies, and they didn't believe her version. They didn't believe the government proved beyond a reasonable doubt that he was guilty.
She had visible marks, right? So we don't call that circumstantial evidence. That's direct evidence, right? There's black eye, there's blood.
She had, to be honest with you, interestingly enough, the jurors' first question after they were deliberating was, "Can we please see the photos again?" And the photos were horrible.
And you
I
thought
I
you were
lost the case.
fucked when you saw those pictures.
Fucked. Exactly, because she had black eyes. And the second fact is, see, the police, to me, state troopers, they didn't really hurt me too bad, other than the fact that they saw blood on his pants and shoe. They arrived after the fact. She's seated in the car when they arrive. They don't see any interaction between them. They see her injuries, and they see blood on his shoe and on his pant. Now, I had another fact that helped me out in the preliminary hearing, which
Okay.
saved me, in my opinion. So you asked me about the preliminary hearing. One fact was he let me back in the car. That's what she said at the preliminary hearing.
Right.
She didn't say that at trial. That was something I hammered on, especially in my closing. The second fact is, quote, she said, I got her to admit during the preliminary hearing that she sent my client a text message. I got fucked up. Okay. I got fucked up. And that was before, and I got her to admit in front of the jury, you sent that text message before you got in the car with him, correct? Yes. And she kept trying to explain. The DA had to do redirect. But the point is, I had my client testify that she got beat up by someone before she got in the car.
Oh.
And he was mad at her for cheating on him with some guy that beat her up. And now she's trying to blame him.
Oh, I see.
You
And the
understand the
fact that is
theory I got?
the fact that she said, "I got fucked up," instead of "You fucked me up."
Right. I got fucked up. Now she was trying to say it was St. Patrick's Day. She was saying she was drunk with alcohol.
Oh,
My client was nope. She got fucked up. She was beat up. That's why she wrote fucked up.
and the DA didn't have score any points with him. He was a good witness.
No, he was a good witness. He had no prior record. He was a good witness. Good
So
witness.
he walked out free man.
Walked free.
Was
Free
he
man.
sitting in jail that whole time?
He was in jail for part of the time, but he ended up bailing out at some point.
Right. What's the bail system like in Philly?
It's 10%. So they set a monetary bail amount. Could be 100,000, could be 10,000, could be 1,000, and the government acts as the surety. It's you just pay 10%. The family or the person pays 10%.
Is there bondsmen you can hire?
You could, but it's there you could, but in reality, the government for whatever reason in Philadelphia, it kind of only makes you put down 10%.
And you'll get your money back when you're done.
You get your money back less an administrative fee. Correct.
Okay.
As long as you show up to court, it's not about guilt or innocence. You get your money back as long as you show up to court.
Right. And when is the bond set? Who sets that?
So in Philadelphia, when you're arrested for a misdemeanor or felony, it doesn't matter which it is, you're arrested and you're taken to a police station, one of the 20 plus police stations in Philadelphia. Within the next 12 to 24 hours, you're arraigned by Circuit TV. That arraignment is done in a courtroom in the Criminal Justice Center that operates 24 hours a day. So that arraignment courtroom is, I've been there 3 in the morning, 4 in the morning. They go to every police station in the city every hour on the hour. And whoever, if there's one person or 10 people arrested in each police station, every hour there's a commissioner sits that sets bail and tells you what you're charged with. If you can't make bail, then you're transferred to the county jail. If you can make bail, you're released from the police station.
Oh, I see. So the police, like in Connecticut, for instance, unless you're picked up by warrant, if the police arrest you, the desk sergeant at the police station sets
No,
the amount, and
no,
then you can have it lowered.
it's the police recommend charges. The DA is the only entity that charges.
I
So
see.
the police recommend charges. The DA then approves charges, and then it goes to an arraignment courtroom where there's a DA and a public defender, and you're presented with your charges, and bail is set.
I see. So you don't even have time to
In the
hire a
counties, that's
private
done
lawyer.
by a judge. In Philadelphia, it's done by a bail commissioner.
Right. And so people know every judge in Pennsylvania is elected. Is that right?
Yes.
Including the Supreme Court.
Including the Supreme Court. They publicly elected, they raise money, they campaign,
Right. So
and they run for reelection.
so can a defense attorney go to a fundraiser for a judge they peer before?
100% yes, all the time. But as a matter of fact, the guy I work in his office hosts fundraisers for many judges, including justices of the Supreme Court that run.
Wow. And so
Of
you're
course you can.
so you're
Food,
able
drink, wine, everything.
Philadelphia. All right. So
That's Pennsylvania.
I'm sorry, Pennsylvania. And that's statewide or
Yes.
Commonwealth wide, as you guys like to say.
Commonwealth wide. Yes.
Commonwealth wide.
One of the 4 commonwealths in the United States.
Right.
Massachusetts, Pennsylvania, Virginia, and Kentucky.
That's right. And actually, if I recall, in Washington, D.C., where you and I lived for many years, the 4 Commonwealth streets actually appear from north to south in the city in how they appear in the United States, if you've ever thought about that.
Well, the main part is the 3 main commonwealths, Massachusetts and 3 original colonies, Massachusetts, Pennsylvania, and Virginia. They make up the 3 main streets of
That's
Washington,
right.
D.C.
Mhm.
Massachusetts Avenue in the north,
Mhm.
Virginia in the south.
That's right.
And the dead center is Pennsylvania
Well,
Avenue.
but that's
connecting the White House to the
geographically,
Capitol.
but that's geographically how it is, right? Where's
Right.
Kentucky Avenue? I don't even know where that is in D.C.
I don't even know. But it's the 3 main ones.
And-
Massachusetts,
but-
Pennsylvania.
But a Commonwealth really is it's part of one of the United States, so it's
Yes,
just
it's a state, but it never dropped. Those 4 places never dropped the Commonwealth name.
designation, right? And so it's people say the Commonwealth, but in reality, it makes, other than some vestige of the history, it doesn't really change anything, right?
Well, the one thing it changes is in New York and New Jersey, for example, and probably Connecticut, it's state of New Jersey, state of New York
Right,
versus the
okay.
person. In California, it's the people versus the person, like people versus O.J. Simpson.
right.
In Pennsylvania, Massachusetts,
Commonwealth.
Virginia, and Kentucky, it's the Commonwealth versus the person.
All right,
So
okay,
for criminal law, it's a term of art we have to use.
right. Right. And who is the and one other thing, I want to get back to some of this stuff, but you guys also have um prothonotary. Did I say that right?
Yes. So the prothonotary is the clerk, protho notary. Protho meaning first, notary being keeper of the record or
Oh, interesting.
scribe. Protho notary, the first. It's the where the civil prothonotary is where you file lawsuits in Pennsylvania.
I see. All right.
Prothonotary law.
Right. And is there a prothonotary for criminal?
No, criminal's just clerk of courts.
Just clerk of courts. All right. So let's get back to a little bit on this on the criminal
But the
side.
Supreme Court has a prothonotary, the Superior Court has a prothonotary, and the civil has a prothonotary. So if I'm filing a criminal appeal, it gets filed with the prothonotary of the Superior Court for the mid-level appeal, Supreme Court for the highest level appeal,
Gotcha.
for the prothonotary's office.
All right. So on the criminal stuff, so we talked about how you pick a jury. You want people that are going to keep an open mind. You want people that are cynical or skeptical about the system,
Yeah,
maybe have had interaction. How many jurors are needed constitutionally in Pennsylvania for a criminal case?
12 unanimous jurors. So we normally seat 14, two alternates, and many times I've needed to deep into the alternate. During the trial and deliberation, jurors get sick, they don't show up, they
Right.
have commitments. I've had trials where we've used one, if not both alternates.
I see. So you need 12 and they all have to be unanimous.
Correct. And if they're deliberating and one of them gets sick, the alternate comes in. You have to start deliberations anew.
Oh, so the
You cannot
alternate
pick
does
up on
not
what the
sit
other.
in the deliberations.
Correct. The two alternates are excused at home. They have the gag orders on them, and if needed, they're called back,
Ah,
and then they have to re-deliberate.
okay. So you have
Only 12 are in the back
12
for,
seated.
for deliberations.
Okay. Are there opening statements in Pennsylvania?
Of course.
Okay, well, we don't have them here.
No,
You just call your first
no.
witness.
There's opening is very important. The DA outlines the case and usually say things. And to give you another example of how the case I won last week, just to use that case, fresh in my mind. The DA comes out and says, and he punched her, and he gave her black eyes, and he punched her, and he punched her. So when I got my opening, I attacked the DA right away because at no point in the police report
Oh, it
or the
doesn't say
preliminary
punch.
hearing does she ever say the word punch. She said open hand slap. Now it sure as hell looked like someone
Right.
punched her, which helped my case, but she had two black eyes. But it was she admitted even in the court to the jury it was open hand slap, 10 open hand slaps.
Right.
Okay.
So you said, wait a second. The prosecutor has the burden. This guy out of the bat is already telling you bullshit that's not
Right.
in compliance with anything.
I said, ladies and gentlemen, of the jury, the prosecutor's already told you punch. I'm going to tell you right now, by the end of this case, I don't think you're ever going to hear the word punch by anybody. So already the prosecutor's starting off on the wrong foot with you. So when I tell you keep an open mind, right here we have reasonable doubt. I don't. The witness isn't even going to say
Punch.
punch.
Right. So who you right, and you have no obligation to. We don't have to prove anything. But if you want him to,
Right.
he wants to send my guy to prison beyond a reasonable doubt, and he's already telling you horse shit.
Right. The second thing, the
That's
most
interesting.
reason the opening for me, I don't care if it's a murder case, a rape case, or a drug dealing
Right.
case. My openings are generally speaking almost the same. They're pointing out constitutional law. One of the biggest things I tell the jurors is I walk over and show them my defendant, and I say, ladies and gentlemen, the judge told you during jury selection and before the trial started a law. And everyone already told you have to follow the law of the judge. You know what the law is? That the person seated there is presumed innocent. That means, according to this judge, the law he told you during jury selection and during his initial opening charge was this person is seated there innocent. You're looking at an innocent man. You're looking at an innocent man. And then I walk over to the government's table and I pound their table and I say it's the government's burden to prove that person guilty beyond a reasonable doubt. They always have the burden. Defendant has no burden. And the government not only has to prove the person guilty beyond a reasonable doubt, they need to provide evidence on each and every element of each
Right.
and every crime that this person has done it. Not just generally speaking, it's each element of every crime. So you're looking at an innocent man right now, person's presumed innocent. It's the government's burden to prove them guilty beyond a reasonable doubt. And then I go over what that is. And I explain the difference between City Hall right behind you, preponderance of the evidence, and reasonable doubt. I do that right in the opening.
How do you build rapport with them? Is it just by being like a teacher? Like I said, you have a very you love to
Right.
teach. You love to teach people like you just did. You were telling them, you're people maybe that didn't have the best schooling, or maybe they did, or they didn't go over this a civics class, but you're telling them, look, this is the beautiful part of America. This is what they have to prove. Follow these
Exactly.
instructions and you're going to be okay. How do you
Yes.
do you ever try to like relate to them as like a fellow Philadelphian? Like what do you like, how do you build any
I
rapport like
relate
that?
to them by my language, the way I speak. I'm not using any, I'm talking to everyday
Ah,
people, a lot of them unemployed, a lot of them without jobs, a lot
right.
of them retired, a lot of them with low education.
Right.
The last thing I'm going to do is use big words. You
Simple.
know, I'm talking from the street and telling them like it
Philly
is.
street talk.
Philly street talk, and I'm explaining the law.
Are you ever
And
could you ever swear?
if I don't know about swearing directly, but I mean, obviously, if it's part of the case, you
Could you say
can.
that, like, could you go there, like, because one of the ways that if I did juries, I might relate. I'm going to say, and you got to put on your horseshit meter and determine, does it pass the smell test or is it horseshit? And use your instincts on
I
that.
guess you could say something like that. I would just probably, for me, it's more about just engaging with them, and I don't use notes. When I go up to talk to the jury, by not having a single sheet of paper or
Right.
nothing prepared and doing it all from memory, that type of engaging, and I just walk around the courtroom and talk to them, look in the face. Every prosecutor I've tried a case with uses a podium
Right. And they
and
read
is
all their
reading.
questions. Yeah.
The reading. I do almost everything from my head. I may make a couple notes on an outline for a closing, but I often don't even refer to it because I just walk around. I do often read from a transcript in a closing. I may read quote and hold it up to him and say, quote, I asked this question and the response was, he let me in the car right here, quote. So I may read that, but I'm not reading anything. The closing's coming right from my
But
head
how does that for
based on
you?
everything I saw in the
But
case
how is that? Why is that so effective for you?
because it helps engage with the jurors
Ah,
and create a bond. When you're just reading, you lose them. When you're
you're
doing it the way I do
you're
it,
their cousin that's
it
over
actually
for you're their
shows them your
cousin
personal
that's
belief in the case.
right. So you're their cousin that's over for a barbecue and
Right.
asking how your family is, and you're having a conversation as opposed to some lawyer who's got notes and they don't feel connected to him.
Yes. Correct. Correct.
So,
Correct.
and what do you think that bond does? Does it? I mean, obviously for you, you don't have the burden, but most people are convicted, right? So, for you to get the not guilty, how does that play in for you? Do you think that they trust you more? Or what do you think?
It just I presented them with a reason, a plausible explanation or a reason to doubt. I presented them
You're
with
more believable because you're talking from the heart.
right.
So, would you recommend, like, if you were teaching a trial advocacy class, would you recommend people to stop the notes, learn your case, and connect
Right.
with the jury?
You got to. That's the number one thing. And to be honest with you, uh, overkill hurts too. Ask the irrelevant questions. When I get up there, I'll ask like the key questions. I'm not going to stay up there too long or I'll get burned.
Oh, I
So
see.
I go up there, I ask the key questions I need, I get the evidence I need to make my closing.
And sit down.
Okay. If I stay up there too long, I may bring out too much evidence I don't want. Okay.
Right, because right,
So
you just right for you want to put the points out there that you can use to sow the seed of doubt, and because all you need to do is
correct.
sow the little bit of doubt, and you're done.
Exactly.
I see. So well, let me ask this question first. How do you make the determination as to whether to put a defendant on? Now, as we know, a defendant has no obligation under the Fifth Amendment of the U.S. Constitution, and certainly whatever the state equivalent is. But
Let me tell you
how do you
this.
make the
Philadelphia
determination?
is a little different.
Okay,
I'm telling you, Philadelphia is a little different in my opinion. Philadelphia,
Philadelphia or
the jurors
Pennsylvania?
want to, right. What?
Philadelphia or Pennsylvania?
I'm saying Philadelphia. Outside Philadelphia, it's a much more conservative area, and I'm going to have a lot harder time with the defendant.
Okay.
In Philadelphia, I've put a defendant up many times, especially in allegations of rape where you need to, where someone says he said, she said,
Mm.
where she said he raped me, and the
It's a
defendant has to
credibility,
testify.
right?
If you don't have to put the defendant up there, you're done.
Right.
In
And
those,
Scott, just as a quick aside, I know from you teaching me this that in Pennsylvania there's a jury charge that you can just believe the complaining witness
correct.
and there's enough to convict.
It's the hardest charge to overcome, especially in a child rape case. The testimony of the child victim standing by itself is, if believed by you, is enough to convict. That charge is terrible. I got to put the defendant up there to give some kind of explanation. I put defendants up with criminal falsity and won cases many times.
Criminal falsity meaning
Criminal
people that
falsity
have
means they have prior
convictions.
convictions for a crime of lying,
Right.
robbery, burglary, theft. I've done it many times. And what I tell the defense to is I bring it out during my
You
examination and I
contextualize it.
say, own up to it. Own up to it. Say, yeah, you know, I was poor. I lived on the street.
I stole.
Yeah, I stole a pack of gum or some batteries from the 7-Eleven around the
The,
corner.
the
And
Jean
I was
Valjean,
convicted. And
the
I
Jean
pled guilty to
Valjean
that.
defense.
Right. But guess
My
what? I never
sister's
raped
child, my
anybody.
sister's child was
Ever.
close to death. You will starve. You
Yeah.
will starve again. um,
Right.
right. So you contextualize it. So you're saying, let me just stop you for a second. So first, you're saying, because of the jury charge and the nature of the case, you may be compelled to do it because you have no other way around it.
Correct.
What about a
And
case without that charge? How do you make the
I've done it in
determination?
cases without that kind of
But how do
charge.
you? But what's take us through your thinking?
I got to speak to the defendant and see what their story is and if they can tell their story plausibly. If they can do it and they don't have much baggage, they're good to go. And the DA, I'm not that worried about because there's not. And the case I had the 2 jury trials ago, the last jury in Philadelphia before the new year in Philadelphia County was a case involving my client and his cousin who carjacked a lady on day 1. And on day 2, they robbed
Alleged,
a
alleged
Taco
to have,
Bell.
alleged to.
Alleged. They robbed a Taco Bell drive-through at gunpoint, all on video camera, in the carjacked car. The cousin, who was the passenger in the car and point the gun inside the drive-through window on video, he pled guilty and got state prison on Friday. On Monday, my client and I went to trial. They presented, my client was in the car. And my opening was, I'm agreeing with everything the police say. Everything the police tell you in this courtroom will be true. I have no dispute of one word they're going to say. My client was driving. The passenger, they were in a carjacked car. The passenger, my client's cousin, he had a gun. And when they pulled up to the drive-through, he gets out of the passenger seat, walks around between the car and the wall. And as they creep up to the window and she unlocks the window, the cousin puts the gun in there and robs the drive-through. Gets back in the car and they take off and drive away. Police immediately get behind them. The car crashes and gets destroyed, and they arrest both people and recover the gun. Okay?
Easy case for the prosecution, they thought.
Easy case for the prosecution. My guy's dead to rights. He's in the car. There's a gun. There's money.
No dispute.
There's no dispute. And my guy was wearing a ski mask. Okay? And that was federal.
And I have a question, Scott. They weren't coming back from the ski resort, right?
Right, of course not. I put my client on the witness stand in this case after agreeing with everything the cop said.
Because you had no choice.
No choice. And I had nothing to lose.
Well,
And he said, no, he was going to be convicted
right.
anyway, right? The evidence was ironclad. And it's on video. There's color video of my guy in the driver's seat from Taco Bell, 4 angles. He goes, I didn't know my cousin stole his car. My cousin drives up to me. He was doing weed and wet, which is PCP or marijuana cigarettes.
Oh, God.
And he was all acting crazy and nutty. And he was giving me a lift back to my house. I said, let me drive because you're acting too nutty. So he went in the passenger seat and I was hungry and I wanted a chicken chalupa. So I went to Taco Bell and my cousin jumps out of the car and I think he was sick. I thought he had a vomit or something. I'm ordering my food. Next thing you know, I'm at the drive-through window to pay the lady and he sticks a gun in there and is robbing her. And I put my hands up. I put my hands up like this 3 times. I put my hands up, right? And I'm saying to the lady, I don't know what's going on. I don't know what's going on. I don't know what's going on. And on the video, you see him put his hands up like this. 4 times he does this, right? The cousin gets back in the car, and he said, then he pointed a gun at me and told me to drive away. Cops get behind us. He said, drive, drive, or I'm going to shoot you. I drove. I crashed the car. Police arrested me. I had no gun on me. I had no money on me. That's the case.
So
Not guilty.
Not guilty. So the police. So he says that, and
I agreed with every word the cop said.
But that's brilliant. But did the prosecution say we got to get Your Honor, we need a continuance to bring in the convicted guy?
Too late.
Oh.
We're in the middle of a jury trial. There's no continuances.
They don't do that. They don't say.
I don't have to present my client has Fifth Amendment rights. We don't have to say what he was going to say up until that last second.
No, right. So when you started doing that, did the prosecution go wild?
No, they didn't know what to do. They were caught off guard. They tried to cross-examine him, and he held up on his own, and the jury came back not guilty.
Because the jury thought that, well, this is a plausible story. The guy had a crazy
in a carjacked car robbing a Taco Bell.
Now
the cousin pled guilty.
And was the client at least grateful or no?
No, they're never grateful. It's okay.
All right. Now let's move to the closing. How important, I mean, obviously in our divorce world, we call everything a mosaic. So basically what that mosaic means is every independent piece can't stand, nothing can stand independently. It's all part of a mosaic. If you pull out one piece, the entire thing collapses. And my guess is that to some extent, depending on the case, that's true in the criminal. You're bonding with the jury, you do something in the opening, you make some points in your cross, and then you close. And all of that sort of together gets you where you need to be. But in
Right.
your view, if you had to assign sort of a level of importance on the closing, what do you, how do you think that, how important is that to
Most
your,
important part of the entire case is my closing. Most important part of the
by
case.
a large margin?
A large margin, because during the case, the opening, I'm setting it up. During the case, I'm looking for nuggets, for pieces of stuff I can use in the closing. Right? I don't know what's going to happen. I can't. I'm not. I don't know how the case is going to come out. I know what they said it to the police. I know what they said at the prelim, but I don't know what they said to the jury. So once I have these nuggets, if I get little nuggets throughout the trial, a sentence here, a word here, little nuggets throughout that trial, that's what I sell in the closing to win the case.
So what's your ask? Like, what is your ask of the jury? Like, do you, like, how do you,
No,
you,
to
yeah,
the
what,
jury, it's not even asked. What I tell the jurors is, I say, remember, he's presumed innocent. I start off that, say he's presumed innocent. You're looking at an innocent man. And then I tell them what beyond reasonable doubt is. And that means hesitate or pause. And I'm going to give you the reasons to pause. If you remember, one of the things you helped create in one of my biggest trials was a 1,500 kilo cocaine case in federal court that lasted 4 weeks. The bin of doubts.
the bin of
Right?
doubts?
The bin of doubts. Same concept. What I'm doing at this point is I set it up, and then I spend my closing pointing out all these inconsistencies, errors, nuggets of material that don't make sense, and said each one of those is a reason to pause.
And if you
One is all
paused,
you need.
and if you
You
paused,
only
they
need
haven't
one
met their burden.
pause. Right, they haven't met their burden. Therefore, find him not guilty.
All right.
And then I do my wise man speech, which I do in every jury.
Tell us the wise man speech.
That is a way to engage with the jury, and it has nothing to do with the case, but it gives it to me. It buys me more credibility with the jury than anything the DA will ever
Could you
say.
do it quickly?
Of course,
Do it.
I go through the entire closing, and now I'm at the very end, and I say, "Ladies and gentlemen, jury, before I sit down, the DA is going to have the last word. If attorneys, the judge will have the very final word. But before I sit down, let me just give you one final anecdote, and it's the anecdote of the wise man and the young arrogant boy." This wise man sees this kid pull a bird out of the sky and hold it behind his back. And the kid comes up to this wise man and says, "Sir, I bet you don't know what I have in my hand." And the wise man says, "I saw you have a bird. You pulled it out of the sky and put it behind your back. I saw you have a bird behind your back." The kid says, "Well, I bet you can't tell me if it's alive or dead." So the wise man steps back and thinks for a second. If I say the bird is alive, the boy's going to crush the bird's neck with his fingers and show me a dead bird. If I say the bird is dead, the boy's going to open his hands and let the bird fly away. So the wise man steps back to this kid and says, "Son, it is in your hands. Ladies and gentlemen of the jury, it is in your hands to come back with the only true and just verdict, a verdict of not guilty."
Ah, I see.
Then I sit down.
And it empowers them.
The point is, it takes them away from the entire. It's the first time during the entire trial that nobody's talking about the case. I'm talking to them about some story on the street, and they are. It's the only time I could tell you 12 for 12 or 14 for 14. The jurors are looking at me and engaged because they're like, "What's he talking about now? Wise man, young boy, bird."
Well, that's interesting, right?
And
I was listening, right? That's
right, but I'm saying that it's during my closing. That's the one time I have all 14 jurors looking at me and listening because they're like, "What is he talking about?" It is the biggest piece of engagement, and then I give it to them, and there's nothing the DA can do unless they can be that personable to connect.
and how many
They're too worried about the facts and the evidence and the law.
but how many not guilties did you get? Did you achieve not guilty verdicts in 2023?
Over a dozen
Wow.
in cases where they were. I mean, another case. I have two child rapes back to back.
Oh boy.
One child rape. The only evidence. There's no forensic evidence. The girl says he licked my private area. Their stepsister and brother. She's 12. He's 23. Okay. I felt there was reasonable doubt. I felt out of all my cases, that one had doubt. It was only her word. He had good character, and in Pennsylvania, good character can raise a reasonable doubt by itself.
Oh,
You have
interesting.
good character. Okay, that's a law the judge tells them. Good character, people of good character don't normally commit crimes.
But you
That
open.
can
But
raise
if I
reasonable
remember from
doubt.
evidence, you open the door on that. So if you put on good character witness, they can put on bad character witness. Is that right?
But this person had no bad character. He was the brother. He did nothing wrong.
Right.
He allegedly licked her in an inappropriate area.
Right.
Okay. And she had a crush on him, which cut both ways. Crush helps me that she is obsessed with him, but crush hurts me that she'd be willing to do these things with him. Right.
Right.
So she had a crush on him. And then he broke up with her. He moved out of the house. And that's when she made the allegations. Jury comes back guilty on that case. Okay. And they just believed the little girl. And one of the things the jurors did say to me after the fact, he admitted that he braided her hair. And they felt a 23-year-old muscle building guy braiding a 12-year-old's hair just was odd to them. They felt that was odd. That was a fact that was odd for them. Okay. The next week, I have a biological brother accused of raping his biological sister over the course of 6 years, through the ages of 8 through 14.
Like penile
Okay?
rape.
Horrible stuff. Okay. They're in this family. They were from Nigeria, very African religious family. And what was a huge factor in this case is the parents were on my client's side, the son. They were mad at their daughter that she would go to the police and she's now in foster care. And they felt she destroyed their family, not their son. So the parents testified on my client's behalf. During the trial, not in the presence of the jury, my client asked the judge to plead guilty. He said, I did it. I want to plead guilty.
Wow.
And the judge said, no, we're in the middle of a trial. We're going to finish with the trial. Because if I take your plea, we have to defer sentencing, do reports, and then you're going to ask to withdraw your plea. So we're going to finish, let the jury decide. During deliberation.
But by the way, when he said that, why didn't they use that against him?
They did.
Right, because
But
I would have said, Your Honor, I'd like to, I'd put that in. I'd have someone testify what he said.
But during deliberation, he says it again.
No, boy, but couldn't
plead
they just call one of the marshals in the courtroom and say, it's a statement against interest?
Pleading guilty doesn't mean you are guilty.
No, but he said I did it. You said he said I did it.
He said I want to plead guilty.
Oh, okay, all right.
And he said it again during the deliberation.
Okay.
The jury came back not guilty all counts, and they felt the fact that the parents were on his side gave reasonable doubt.
Wow. Wow.
And he said he did. He said out loud, not attorney-client privilege. He said out loud in the presence of others that he did it. So.
And so the jury just they took that and ran with it. So what if somebody is trying to build a criminal defense practice to get their skills better, to be better at what they do, what is your number one takeaway to tell people in terms of jury work and getting
watch and learn. You got to sit in courtrooms. Being at a desk, you're never going to learn anything. In the courtroom and see what other people do. Take the best of what they do, leave the worst, and try as many cases as possible. The more you try, the better you are.
Right. So try the cases.
I had a jury listed this morning. The difference is the DAs know I don't fool around. I'll go to trial on anything. It was a cockfighting case. They withdrew the charge against my guy. Withdrawn.
Why? Because they know that you would have. But what did they have to lose though? Just their time?
I guess they would have had a really struggle to get in humane officer and stuff. It wasn't regular Philly PD. It was SPCA. It would have been a struggle for them to track down witnesses. They just didn't want to bother. The DA didn't want to bother.
Oh, and it was marked ready for trial?
Jury trial this morning.
Oh, and they didn't subpoena people in advance?
Ready. I had no idea. I was ready to go. My clients were ready to go. I had his family there, his mother there, his wife
What was he alleged to have done?
Involved in a cockfighting scheme. The police raid a place. They're using the roosters to fight with razor blades strapped to their legs. He's there. Mere presence by itself isn't enough. But in his pockets, he had hundreds of yards of dental floss. And an expert witness was going to testify that is used to bind the razor blades to their ankles of these roosters.
Oh, and then they bet on which rooster is going to kill the other rooster.
Correct. And they make money. If all he had in it was dental floss.
No, and
now this case would have been all in Spanish. You didn't speak English. I had another case recently, child rape, grandfather raping a granddaughter over the course of a couple of years. That was in Bangladesh. That case I didn't win, but the mother, grandmother were on my client's side. So the grandfather had his wife and his daughter and the granddaughter was in foster care. So that was a similar kind of dynamic, but the jurors still found him guilty.
But Scott, how do you? What else? What advice would you give to somebody that's handling these things? You're seeing the worst in humanity, right? Rape of a child,
Or
child
first degree murder.
pornography.
I'll give you an example of first degree murder where putting a defendant on the stand hurt me. They have video of someone shooting and killing someone at 3 p.m., broad daylight, on Broad Street at Broad and Erie over who runs Lucy Cigarettes on which corner of Broad and Erie. And my client is alleged to walk up behind this guy and shoot him in the back 3 times in the middle of the street. The guy collapses and bleeds out on the street. Okay. The problem is they never see the face to my guy. So they have a crack addict whore prostitute that's sitting on the corner that says the one eye guy did it. Okay. And my guy had one eye. One eye was blown out. He had one eye. So she said the one eye guy did it. I beat her up pretty good on cross, but my client couldn't wait to take the witness stand. I didn't need him on the witness stand. He wanted to testify.
Oh God.
He gets up there and did great on direct. On cross
Of course.
examination, they go, "Well, if that's not you, who was it?" And he goes, "It's the cops dressing up as me.
Oh, that was the end.
Because that's my clothing." But it wasn't me.
That's the fake news defense. Just say fake news. It's fake news.
Oh my God.
What?
I'm like,
No, but
"God,
what? No,
Megan,
but my
you that
question
dumb?"
was, and I'm sorry if I wasn't clear though, but how do you, as a defense attorney, when you see these awful things, like I listen to people's problems all day, and it's awful, right? And you have to take all this in, and it does take a toll at some point, I would think, right? You see, how many child rape cases can you handle before it
To
seeps
be
into?
honest with you, out of all cases, Richie, murder is just really a shooting where someone dies, obviously, or stabbing or whatever. The child rapes are the hardest cases for me to handle. They're the hardest cases that cause the most internal turmoil, especially being the father of a daughter. It's the hardest cases to deal with, where an adult victimizes a young little
But how
girl,
do you deal with it? Though? That's
especially
I know they're
12.
hard. I'm asking you, what do you do?
I defend them to the best of my abilities, but a lot of them make me sick to my stomach, including one case I had in particular that really made me sick was this guy. They offered him an incredibly good deal. He was the male babysitter of 3 little girls who lived
Oh,
across the
you
street
remember
from him.
this case? Yeah.
And he had identity issues. He wasn't sure if he was gay, straight, bisexual. He was very confused about his sexual identity. But he experimented with these 3 little
Oh
girls.
gosh.
And he would take them individually into the bathroom and touch them all over and put fingers and tongue in different body parts. And he victimized all 3 girls. But none of the girls knew that they were being victimized. And they each testified they kept their mouths shut because they thought he was only doing to them and they wanted to protect their sisters. He also had a hoodie, a red hoodie, that he had a hole cut out, and he'd have them put his hand in the pocket to hold his private parts.
Oh gosh.
And they obviously the police seized the red hoodie. The DA offers 4 to 8 years on this case and said they're not going to arrest on the 3rd girl, so they don't have to make the youngest girl testify. Great deal. The guy won a trial. He testified it didn't happen, and that he is confused sexually, but it didn't happen. And jury convicted, and the judge gave him 15 to 30 years in prison.
Oh my gosh.
5 to 10 on each girl consecutive.
Oh gosh. All right. But again,
Sick,
focus
sick
for a
case.
second. How do
Really,
you?
that case, I don't know why, but that case, that really irked me, that case.
But
bad.
how do you
The
deal? But
details
how
were
do you
horrible.
process that though? Like, does sometimes you just want to walk away for a week and not deal with this?
No, you just go to the next case. And the good news is my cases usually aren't back-to-back child rapes. So the next case could be a drug case, a murder case. Your wheels are spinning, you change
But
gears.
what
and
I'm
you're
hearing
focusing
from
on
you
something
is you
new.
just got to deal with it.
You got to deal with it. But it's during the case, you're sitting next to the person. It's tough. It's tough. And you can't let it be visible in your face.
All right. 2 more questions unrelated to law. Best pizza in New Haven.
Sally's.
Good. What type of pizza?
But for me, the large moots is the absolute best.
Good. Right answer. What kind of soda do you drink with it?
White birch beer.
All right, you
specialty
got it. All
set.
right, so Philadelphia guy got it. All right, and best cheesesteak in Philly.
And for me, I like Tony Luke's because I like sharp provolone. So I'll get sharp and mild provolone with fried onions at Tony Luke's at Front in Oregon. Although they changed the name now because
They had some of the tax issues.
father and son had a fight, and now it's called something else.
Oh, Tony and Lucille. I don't know something, but all right. So
Whatever.
that's
Still Tony
sharp,
Luke's.
and no whiz. Could we agree? No whiz, no ketchup.
No whiz. You got to give provolone.
All right, best pizza in Philly.
For me, Tacanelli's is the
All
best
right, the
pizza in Philly.
sourdough.
Yeah.
Sourdough. All right. Well, sorry about your Eagles.
Yeah, terrible. They went down in
I
flames.
know, it was too bad. They didn't play well, but anyhow.
Yeah,
Well, anyone, thank you very much, Scott. Great to see you, and I think that was a great insight into what it's like to be a criminal defense attorney. It's certainly a interesting job. I appear courtside, so I'm trying to convince one person. So it's a much different animal, and I'm working on the preponderance, a fair preponderance standard, which is much lower. But and my cases aren't really about winning; they're just sort of getting a better deal. So it's a
of
much
course, of course.
interesting thing. So I wanted to bring that out. So thanks so much.
Thank you for hosting me.
Yeah,
Thank you for
man, and
hosting me.
I'll give you a call later this week.
Take care.
Take care. Bye.